Retreat! 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 That's right, you probably heard those words today from the governor of New Mexico when it came to her executive order on gun bans in Albuquerque, New Mexico. Stay tuned. Let's talk about how she is in retreat and why the war is not over. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gunner, a constitutional attorney, member of the United States Supreme Court Bar, and author of First They Came for the Gun Owners, the A to Z guide of how the anti-gunners will take our guns if they give them an opportunity, but we're going to thwart them at every turn if we can. All right, folks, breaking news. The governor of New Mexico, Governor Grisham, as you know, last week entered a blanket ban on carrying firearms if you're a citizen, as opposed to, let's say, a police officer, who are basically also citizens and civilians, by the way, but we won't get into that. The governor said you could not open carry or conceal carry a firearm in Albuquerque, New Mexico, even if you had a concealed carry permit and had already been vetted. Well, as you know, this backfired big time on the governor, so bad that she was sued, I think, no fewer than 6 times in state court and federal court. And a federal district court judge appointed by none other than the anti-gun president himself, Joe Biden, actually told the governor and enjoined the governor's law on a temporary basis until early October on the grounds that it violated the Second Amendment, which, of course, the Four Boxes Diner explained exactly that. Now, so what has the governor done? Well, the governor has done a strategic retreat, a huge retreat. So she's eliminated the ban of carrying, not just in Albuquerque, but in the whole county of Bernalillo. And thank you for those of you who helped me clarify how to pronounce Bernalillo, so I appreciate that. So what she has done instead is to, with a magic wand, without going to the legislature, just said, we're not going to ban the carrying of guns, open or concealed, under this executive order anymore. Instead, we're just going to prevent you from carrying a gun, open or concealed, on playgrounds and on public parks. Now, we're going to get to that sensitive place issue in a second. But isn't it quite interesting that she, the governor of New Mexico, just basically said, we're not going to let you have guns in those public areas? Do you think she should have consulted the New Mexico legislature? What is wrong with this woman? My God, is she trying to be the king or the queen of New Mexico? What is wrong with these people where they don't understand separation of powers? You think that they are kings and queens after COVID. And Governor Grisham doesn't seem to be interested in consulting with the legislature. She's just going to go out there and do it, which is probably the way many people on the left really would like. They would like us to be governed by platonic gods telling us what to do because there are betters and smarters than we are. Well, that's not our system. That's not our constitutional system, I'm happy to report. Nevertheless, what the governor has done is modified the executive order to say that she's not going to enforce again a ban on guns in public in Albuquerque, except with respect to guns in public parks and playgrounds. So basically what she has converted is this ban on guns into a quote-unquote sensitive place fight. Government-mandated gun-free zones are sensitive places. Now, you know, if you've been following the Four Boxes Diner, I've been on this even before Bruin was decided. I predicted that exactly this was going to happen, that the anti-gunners were going to get their butt kicked in NYSERPA versus Bruin in 2022, which they did. And then I said that what was going to happen is when they got their butt kicked, they would immediately try to gain ground by declaring everything a quote-unquote sensitive place, which is a euphemism for government-mandated gun-free zones, which is exactly what the anti-gunners have done in places like New Jersey and New York. And I'm happy to say, in many respects, they've gotten their butt kicked by many courts, although that fight continues. So basically what Governor Grisham has done here, she's converted this fight from a gun ban fight to a sensitive places fight with a wave of her governor's magic wand somehow, thinking that she can somehow defend banning guns in public places, public parks, and playgrounds. Now, we're going to get to that in 1 second and point out why that is not true under the NYSERPA versus Bruin, but let's just talk briefly about what's going to happen next in the litigations, because there are, I think, 5 or 6 lawsuits. I think there are 5 lawsuits in federal court and 1 in state court right now. I think those will likely continue for the moment for a couple reasons. First of all, the executive order that she entered last week is still in effect, right? She has not gotten rid of it. She has modified it to narrow the scope of it, but it's still in effect. That demonstrates a couple things. One is it demonstrates that she still believes that the executive order is valid. Number 2 is that I think she's made comments that she still thinks that what she's doing is lawful. She's said that in interviews. And number three is, of course, it is still in effect with respect to playgrounds and public parks. Now, the reason why all of this is important is because she's done this, I think it eliminates the opportunity for the government in New Mexico to claim that this case is moot. If, as you know, if a case is moot, meaning it's kind of over, then you often lose your ability to litigate the case in federal court because under Article 3 of the United States Constitution, Article 3 U.S. Constitution, federal courts only have jurisdiction to hear cases, cases that are cases and controversies, which are actually ongoing, real, actual fights and disputes. And if a case becomes moot, well, there's no more fight. However, there's an exception to the mootness doctrine, which we've talked about before. That is if a case or a situation is capable of repeating itself and the issue presented is one that could make it hard to easily, or make it easy to moot. The classic example of this is, challenging laws against abortion or restricting abortion. Because, for example, every 9 months, a woman that sues over an abortion law is obviously that is going to get mooted because every 9 months she's going to have the baby, and therefore she loses standing arguably, and it becomes a moot point because she's had the baby. So to get around these things, there is an exception to the mootness doctrine that says if things are capable of being repeated and it's not really viable to resolve the whole case in the time that usually it takes to hear a case, then a court can hear a case that would otherwise be viewed as moot. And I think that's the case here because it's pretty clear that this governor intends to continue to fight over and advance these kind of executive orders on gun control, and the executive order is still in effect, thus means that it's not moot, and even if it were temporarily moot, it's clearly capable of coming back to haunt gun owners. So I think a court's going to view this as not moot under the circumstances, so I think this case is going to continue. And of course it is going to continue because she's arguing that she has the authority to ban guns in playgrounds and public parks. But if you go back to the year of our Lord 1791, when the Second Amendment was adopted, right? You look at the text of the Second Amendment, which obviously we know this is, carrying a gun is implicated by the text of the Second Amendment. The Bruin Court said that specifically. So then you have to look to see, then the burden shifts, right? Once the text is implicated, the burden shifts to the government to show that there's historical analogs that justify the modern day gun control law. So here you're going to have a situation where the governor of New Mexico has to come forth with historical analog laws at the time of our founding to demonstrate that indeed you could ban, or they banned guns in public parks and or playgrounds, and that is clearly not going to be doable because, again, people had guns in parks all the times. Students and children, would carry guns. They would often hunt after school. So there really is not going to be any historical analog laws dealing with preventing adults, at least, from having guns in playgrounds or having guns in these public parks. So what I think the Governor Grisham is going to do is she's going to do which I also predicted, is they're going to go to the late 19th century and try to argue that the 14th Amendment and the post-14th Amendment period is relevant, but that's just not going to work because that's inconsistent with the Supreme Court precedent, notwithstanding the general language in Bruin that says whether you look at 1791 or you look at the late 19th century, we don't need to get into that here in the Bruin case because either way, the anti-gunners lose. And that language, of course, has been tried to, the anti-gunners have tried to exploit that language to allow them to look at the late 19th century post-Civil War period to draw on more gun control laws. Why? Because there are more gun control laws in the post-Civil War period for several reasons, one of which is a lot of these gun control laws were enacted to try to prevent the freed African-American slaves from having guns. So you had a rise in gun control laws associated with trying to stop the freed African-American slaves from, indeed, having the right to bear arms. And there's a bunch of other reasons why that was the case, including attacks on debates and issues associated with the former Union officers and the Confederates and so on, and a lot of anti-immigrant, thoughts that also motivated some of these kinds of laws. The bottom line, though, is it's going to be 1791 because when the Second Amendment is adopted in 1791, you have to look at the meaning of the text of the Second Amendment when it's adopted, and it was adopted in 1791. So why would you care what people in the late 19th century thought about the meaning of the Second Amendment when you're trying to understand what it meant when it was adopted in 1791. This is like saying that you and I enter into a contract today in the year of our Lord 2023, and 100 years from now, we want to know what people 100 years from now think about the contract between you and I entered into in the year of our Lord 2023. No, the way you would try to interpret the words on our contract in our written document would be, what did you and I contemplate and think about when we entered into it in 2023. Think of the Second Amendment like a contract. In 1791, the American people entered into the contract of the Constitution and the Bill of Rights. So when the people entered into that in 1791, that is what you got to look to. The purpose of the 14th Amendment, of course, was adopted with the 13th, 14th, and 15th Amendment, was basically about bringing the freed African-American slaves into the American system and turning them into citizens, giving them the right to vote, giving them, freeing them from slavery, giving them equal protection of law, things like this. That was the point of the 14th Amendment in the late 19th century. It didn't change the meaning, It didn't change the meaning of the Bill of Rights. All it did is extended the Bill of Rights to a new group of people, i.e. the freed African-American slaves, and it extended the Bill of Rights in terms of restricting the ability of states and localities to engage in conduct that would otherwise violate, say, the federal Constitution, the Second Amendment, and so on. So that's all it did. It didn't change the meaning of the rights. And because it didn't change the meaning of the rights, any gun control law in the late 19th century cannot be considered, because the only way that would occur is if we were changing the meaning of the Bill of Rights, which we know for a fact that's not allowed in Supreme Court precedents. The most basic example of this is just a couple of terms ago in the Espinoza case against Montana. Espinoza against Montana, there were 30 anti-Catholic laws in the late 19th century that had been adopted by 30 states, mind you, that basically prevented public monies from being used for religious type schools. So John Robertson, the Supreme Court, said the fact that you had 30 state laws preventing monies from going to religious schools in the late 19th century is not a basis to alter the meaning of the First Amendment at the time of 1791 when it was adopted, and they rejected all those 30 state laws from the late 19th century as a basis for altering or misconstruing the meaning of the text of the First Amendment or the history of the First Amendment. They were all rejected. The Supreme Court's going to do the exact same thing when it comes to the Second Amendment, because again, the late 19th century history can be relevant to the Second Amendment but only as a confirmatory analytic. In other words, you look to 1791 text and history to understand the scope of the right, and then you can look to later periods in time to confirm the 1791 understanding, but you cannot look to later periods of time like the late 19th century as a basis to contradict the 1791 understanding of the Second Amendment. The reason why all this is important is to the extent that they can find any gun control laws dealing with playgrounds and or public parks in the late 19th century, that's not going to be considered as relevant, because at the time of the founding, 1791, you did not have any restrictions on guns in parks or playgrounds or anything like this, and therefore it's just not going to fly and will not be upheld. Now, I will let you know that the district court in New Mexico is pretty liberal, and the Court of Appeals, the 10th Circuit Court of Appeals, is also by and large a liberal court. So this is not a good jurisdiction for gun rights as a general matter. So just be aware of that. May not be the best place to litigate the sensitive places issue. There's a good chance we could lose just by virtue of who the judges are. Nevertheless, just something to keep in mind. The other thing is, a lot of you asked me, is it possible that she could lose some money? It's possible because the law basically is that if an individual government employee or governor does something that so blatantly violates the Constitution, where she's ignoring something that's on all fours or some precedent that's clearly applicable, it's possible that she could lose some nominal damages here. I'm not sure that ultimately it would be worth doing it here, but nevertheless, that is a possibility. But again, I don't think that's really the real course. I think the real goal for the Second Amendment movement in this case is just to enjoin these laws and get favorable precedent and not to get any money out of the governor. Although getting attorney's fees under 42 U.S.C. 1988, which is the basis for the lawyers to get their attorney's fees, that would be perfectly fine here. But again, trying to get money out of the governor's pocket, I don't think is really a priority, because you're not going to get enough money, because the damages are really unquantifiable here, and you're only going to get nominal damages, and it's probably not worth the fight, or as they say metaphorically, the juice will not be worth the squeeze. So, all right, folks, but anyway, the good news is, big win in New Mexico. The governor is in retreat in New Mexico on her gun ban, and that is always a good thing. If the trend is our friend, we like the trend, and right now in New Mexico, the trend is our friend. So we'll keep you abreast of changes out there. And again, if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again here soon at the Four Boxes Diner.
Orders up. Table 2A.